Okay, good afternoon, everybody. Ladies and gentlemen, we're about to begin the event, so please turn on your camera and make yourself comfortable. Good morning, ladies and gentlemen. My name is Christina Nicolin, and I will be your host for today's visiting lecture. To the Honorable Professor Dr. Retno Saraswati, SIM Hum, and the Honorable Dr. Trilaksmi Indreswari, SIM Hum, as the Vice Dean of Academic and Student Affairs of Faculty of Law, Universitas Diponegoro. To the Honorable Visiting Lecturer for today, Professor Markus Wagner, the Professor of International Trade Law, School of Law, University of Wollongong, Australia, and a very warm welcome to the participants and the lecturers, as well as students of the Faculty of Law, Universitas Diponegoro. I would like to express our gratitude for your presence in this memorable occasion today, and it is a pleasure to have you today. We would like to also thank God for His blessings so that this afternoon we could gather here for the lecture regarding the future of international economic governance in the Indo-Pacific and beyond. Before we begin, allow me to read today's agenda. First, we will hear a welcoming speech from the Vice Dean of Academic and Student Affairs of Faculty of Law, Universitas Diponegoro. Second, the lecture will be open and guided by our moderator, Mr. Pulung Widhi Hananto. And third, there will be a presentation delivered by the visiting lecturer, Professor Markus Wagner, which will be followed by a question and answer sessions. And lastly, there will be a brief photo session at the end of this event. Without further ado, we will now hear the welcoming speech by the Vice Dean to Dr. Trilaksmi Indreswari SIM Hum. The time is yours.
Yeah, thank you, Christina. Assalamualaikum warahmatullahi wabarakatuh. The Honorable Professor Dr. Retno Saraswati SIM Hum, Dean Faculty of Law Universitas Diponegoro, to the Honorable Professor Markus Wagner, Professor of International Trade Law, School of Law, University of Wollongong, Australia, students, all participants, good morning. Alhamdulillah, praise and thanks to Allah Subhanahu wa Ta'ala. We are here to join visiting lecture program without any obstacle. On behalf of Faculty of Law, Universitas Diponegoro, I extend my very warm welcome to Professor Markus. I would like to express our highest respect and gratitude to Professor Markus for accepting our invitation. It is an honor and a privilege for us to have Professor Markus as a guest lecturer today. And today's topic is the future of international economic governance in the Indo-Pacific and beyond. This is an interesting topic. We do hope this visiting lecture can improve our student knowledge and skill. In closing, once again, thank you, Professor. We look forward to continue our academic collaboration between School of Law, University Wollongong, Australia, and Faculty of Law, Universitas Diponegoro. To all participants, thank you for joining this program. Enjoy the visiting lecture. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you very much, Dr. Trilaksmi, for the opening speech. Ladies and gentlemen, before we start the session, I would like to briefly mention today's topic and lecture, as well as today's moderator. The discussion today will be led by today's moderator, Mr. Pulung Widhi Hananto. He received his bachelor degree from Universitas Diponegoro and received his master degrees from the National University of Singapore and University Kebangsaan Malaysia. He is currently the lecturer of Faculty of Law in Universitas Diponegoro for International Law and an advisor for the FTA Semarang. To start today's lecture, I give the floor to the moderator. Mr. Pulung Widhi Hananto, the floor is yours.
Okay, thank you, Achal, for lovely introductions. To the Honorable, the Vice Dean from the Academic Matter, Dr. Trilaksmi, to Honorable, the notable speaker today, Professor Markus Wagner, distinguished guests, lecturers, ladies and gentlemen, and also the student. Good afternoon. I think it is big hope that you are in a good condition. It is an honor and special for me to inform you that among us, we're having special guests from University of Wollongong, Professor Markus Wagner. And on behalf of the Faculty of Law, Diponegoro University, I say welcome to our faculty, even in virtual, Prof. In this special occasion, as a head of International Office, Faculty of Law, I would like to say thank you and fully appreciate to the Prof. Wagner to accept our invitation and also to join this visiting professor and also our academic program. Well, actually, the topic today that we would like to address and also to discuss today is very important. And to be honest, it's like totally interesting. We all can declare that nowadays, the free trade agreement and our comprehensive partnership in the term of international economic collaboration is to be the problematic issue to be concerned about, to address, and also to discuss in our academic forum. The implication of the free trade agreement, it is clearly impacted on the multi-segmental of the international economic collaboration, not only in bilateral, but also it is indeed for the multilateral. This is also impacted on the spectrum of the global economic, such as like the green economic and also the blue economic as well. As law student, I think it's very important to notice, yeah, that we also have responsibility to continue to supervise and also to criticize the all form of the legal instruments that regulate about the free trade agreement in our country. We hope that this section, it will be give big advantage in the term of the knowledge, especially in the international trade law and also international economic law. And maybe this lecturing and also session is the content about the fruitful dynamic discussions. Now, this is the high time for to listen the presentation from the Prof. Wagner. But before that, we start the section, I would like to read briefly the curriculum vitae of the notable speaker today. Okay. So I think this is an honor that I read the CV from Prof. Wagner. I know that this is outstanding CV, but I make it very fast, Prof. Okay, so with your permission, Prof. Our notable speaker today is Professor Markus Wagner, actually. Professor Wagner is Associate Professor at the University of Wollongong. He joined at the School of Law in 2018 from the Warwick Law School and has previously worked at the University of Miami. Regarding about education background, he obtained his law degree in 2002 and a master's degree in international law in 2005, both from the Faculty of Law and University of Discussant, Germany. In 2005, he also served as the legal counsel for the permanent mission of Germany to the United Nations in New York. In 2006, he graduated from the Stanford Law School with an LLM degree. He is also executive vice president of the Society International Economic Law, or SIL, and the past co-chair in the Junior International Law Scholar Association, or JILSA. Professor Wagner had advised in international organization and has presented at academic and professional conference in the area of autonomous weapon and also international economic law. Professor Wagner teaches and writes in the area of the international law, constitutional law, and also the comparative law. His recent scholarship has focused on the development of the autonomous weaponry and also the compatibility with international humanitarian law and also the various aspects of international economic law. Regarding about the publication, I mentioned about the top 3 publications from the Prof. Wagner, and 2040 is entitled Regulatory Space in International Trade Law and also International Investment Law. Is published in the University of the Pennsylvania Journal of International Law. And also same in this year, and same year, 2014, the humanization of the international humanitarian law, legal, ethical, and political implication of autonomous weapon system. And 2017, the future sanitary of the Pinus Statutory, SPS plus or SPS minus ? Published in Journal of the World Trade. Wow, such a good, interesting topic also. Well, I think that it's such remarkable and outstanding CP. Let's start the function. Without any further ado, I give the floor for Prof. Wagner to deliver the presentation. More or less is 30 minutes until 45 minutes. Or time is yours. You may take the floor, Prof.
Thank you so much. It's an honor to be here with you today, and I hope we can continue our collaboration past this particular event. I'd be thrilled. So let me first thank you and express my gratitude to the Vice Dean, Trilaxmi Intredevali, obviously to Pulung, Widhi, Hananto, who I've been in contact with for quite some time, for Christina, Nicolin, who's the MC for today's event, and everyone else on the staff side who was involved and I've been in email touch with. And then finally, but last but not least, everyone who's here today, who I can't see and I'd much rather be in person with you. And Pulung, we just spoke about this, that hopefully we can make this happen in the next year. The last 3 years academically have just been a different world, right? It's been this, and this has been great in some sense because there's connections like this that are much easier to do. But to me, at least, being there in person is different. right? And being able to talk and interact and see faces on screens. At the moment, all I see is myself, and then some black dots on the top, and I hope to see you in person at some point. So today's topic, and maybe I'll just start sharing my screen right now. Let me know if you can't see it. It should work. It usually does. You just rearrange everything here. So today's topic is the future of international economic governance in the Indo-Pacific and beyond. And I'm thinking about my target audience here, right? It's an incredibly, it sounds really big, right? And in some sense it is, but I'll try to break it down into smaller bits and pieces because I think, as Pulung, you've already said, it's an important topic. And I think it's an important topic even more so today, right? In this ever-changing international relations that we see, one that's becoming ever more complicated, right? So when I grew up, this is probably before your time, Pulung, when I grew up in Europe, it was East and West against one another. It was very simple, right? It was one side and the other side, at least in Europe, right? It was more complicated than the rest of the world. But that then turned in 1989, 1990, the Berlin Wall comes down, happens to be in Germany. I'd never been to Berlin before, but the Berlin Wall comes down. The Iron Curtain in Europe starts to vanish and things become easier again, even more, right? Because now everyone thinks, well, there's only one model out there, right? And in that world, we see the GATT, at the time, the General Agreement on Tariffs and Trade, move into the WTO. We see other institutions at the time becoming more important, right? So I'm thinking about nothing to do with our lecture today, but the International Criminal Tribunal for the former Yugoslavia and Rwanda. We see the International Criminal Court coming to the fore. And so what I always say is to my students in international law or in international economic law subjects, I say this is the kumbaya moment of international law. We all held our hands, right? And we thought the end of history is near, to speak with Francis Fukuyama. I thought he was wrong at the time, right? History doesn't end. There's always a development. It doesn't have to be the development between two poles, but history became sort of easier, it seemed. We all sort of seem to agree on certain things, right? But then falls apart, in my mind, in 2003 when the US invades Iraq, right? Then these institutions start to fall apart a little bit, bit by bit. The WTO was doing really well up until about, I'd say 10 to 5 years ago, depending on where you want to place it, right? In terms of providing some governance model. You may disagree with the governance model, but it was doing reasonably well, right? We had 160 plus 170 countries that joined the WTO. The dispute settlement mechanism was doing reasonably well. We had sort of basically agreed upon rules in international trade law. But then that falls apart, and I'm happy in the Q&A, or Pulung, if you want me to, you just tell me whether you want me to go into greater detail there. But we basically see the falling apart on the what I would call the legislative side, the rule-making side of the WTO. Right? And as of 3 years ago, the judicial side is completely it's no longer what it used to be, right? I don't know how much your students know about this, but the WTO is basically a little bit like a government. It has a legislature, it has an executive, not very strong. Legislature could be strong, but isn't. And then it had the judiciary, and the judiciary was actually quite powerful. But 3 years ago, the head of the judiciary was banished essentially. No further reappointments to what is called the appellate body. And so instead of the WTO, that seemed to be one central place we could all hold on to, right? So, Pulung, I don't know about you, but when I wanted to look something up, I would go to the WTO's website, or I would sort of focus in one place, right? Unlike international investment law, where I have to look everywhere. In trade law, I could, by and large, at least with respect to dispute settlement, I would go to the WTO website and I would look through the 500, 600 disputes, and I would look them all up and I could find everything there. One place, right? So that seemed really uncomplicated. And now it's becoming much more complicated. And this is what today's lecture is about, right? And I think countries like Indonesia, countries like Australia, countries like Malaysia, countries like India, the European Union, but more so Southeast Asia, and this is today's lecture really, are finding themselves in a really complicated space, right? And so I'm sorry to speak for that long without changing a slide, but I think it's useful to understand that context, right? What is this complicated space? That complicated space is China ascending, right? With no soft power from my perspective, only hard power, right? The US not knowing what it wants to do. Under Barack Obama, yes, pushing towards the CPTPP, the comprehensive, well, at the time, the Trans-Pacific Partnership Agreement. Trump comes into power and immediately withdraws from the TPP. And then we now have the CPTPP, the Comprehensive and Progressive Trans-Pacific Partnership Agreement. We have RCEP, the Regional Comprehensive Economic Partnership, and then we have the BRI, the Belt and Road Initiative. And a country like Indonesia is caught in between all of this. And then there's all these trade agreements that are bilateral, then there's these complicated relations with a country like Australia that basically sort of, from my perspective, I'm not Australian, that basically looks at countries in the rim as sort of necessary and a bulwark against China, but doesn't really engage with them on an equal level at some point. And so it's a very complicated space, right? And so what I want to do today is really look at these governance models in international economic law. How do some of the recent large trade agreements stack up? So I'm looking at the CPTPP, and I'll go through all of this in detail, the RCEP, the BRI. And I'll leave out the individual bilateral agreements. There's just too many of them these days. So what I do think is that these three agreements are really agreements that present models for determining the characteristic of international economic relations in the 21st century, not the 20th century, which was the GATT and the WTO, in the 21st century and outside of the EU, right? The EU is a special actor, wholly different, much more integrative, right? Like it almost works like a country. But what we're talking about is international, like intergovernmental relations in say the Asia Pacific or the Indo-Pacific. And so what I want to do is to look at a number of elements, and I'll go through all of these, but what do these agreements cover? How much regulatory coherence do they have? What are their institutional mechanisms? I look at international standards and the dispute mechanism. I apply that model that I developed on these three agreements, and then try to have an outlook essentially at the end to say, what does that all mean for us? And where do we position ourselves? Because I think depending on what model one chooses, you're going down a completely different pathway, right? Of dependencies or being able to influence the dependencies. I think that's very different. And if you just look later on at maps, Indonesia is sort of at the crossroads of all of this in some ways, right? And I think that makes it complicated, but also fascinating and somehow important, right? We like to think, at least as academics, that we do something important, but I do think it is. Pulung, we spoke very briefly beforehand about this. If anyone has any questions about anything I say, please just raise your hands, right? Like I can't see anyone's faces, I only see names on a black Zoom screen, and that's okay. But if there's any questions, just please raise your hand. Probably best to do it with the raising hand function in Zoom, which I'm sure all students are familiar with these days, because some of this is complicated stuff, right? And so if you think it's helpful to explain something, don't hesitate. I'm German, but I can be approached, right? I don't bite, and I'm a nice person, so no question from my perspective. is a question you shouldn't ask, because if I don't explain it properly to you, or if there's something there that you don't understand that's important, then please ask. It's just easier and more interesting maybe. So if we look at the agreements in international economic law, both trade law and investment law, there's a huge rise in these agreements, in the number of these agreements. Not everything is new. A lot of these things come out of the WTO, the GATT, the WTO, and are remain relatively stable. But the qualitative character is changing at the moment, right? What we used to have is agreements where Australian coal or Australian steel gets into China, questions of market access, right? That was sort of the simple thing. Then we talked about tariffs, we talked about quantitative restrictions, and we can go into detail why we had those, right? But what we're seeing now is, away from these market arrangements, is a much closer integration in these trade agreements, and they come with models attached. And I'll talk about these models in quite some detail in a little bit. And so I call them either trade agreements or trade arrangements. And because the BRI is not one agreement, I mostly call it trade arrangements, right? It's less than that, and I'll talk about why that is. Now, if you look at all of this, right, I tried to make a word cloud at one point out of I think this was the CPTPP, and this is roughly what comes out, right? If you look at the screen, this is a word cloud. That's roughly what it is. So what I go through essentially is these 5 elements that I mentioned: subject matter coverage, regulatory coherence, institutional arrangements, standards, and dispute settlement. So I'll go through all of these in detail, right? So most agreements will always have a certain subject matter that it's attached to it, right? Normally, and in the WTO, we used to focus on goods, services, and on intellectual property rights. For various reasons, those were the 3 things. What we now see is an expansion, right? We see an expansion in e-commerce. We see an expansion with respect to how institutionally some of this is underpinned. I'll talk about that. And we see an inclusion of what's called regulatory coherence. Again, I'll talk about this. So the subject matter coverage from relatively narrow goes much, much wider in these agreements. Then if you look at regulatory coherence, and this is the best picture I can come up with, right? I can't really find anything else. The idea of regulatory coherence is to get rid of what's in English is called red tape, right? What is red tape? Red tape is the idea that businesses should be able to operate with knowing the rules that govern what they need to do, right? So the government says, if you want to, I don't know, I'm just grabbing something in my room, right? If you want to import this phone into Australia, it needs to abide by certain standards, right? Now, which standards? Whose standards? Who gets to set these standards? That's all the question of regulatory coherence, right? Questions about whether you're allowed to import an article, under what conditions, right? So we see this in this move away from tariffs, which used to be the big sort of question in trade law under the GATT, where we had these 7 rounds or 6 rounds of negotiations where tariffs subsequently started to decrease. And then we started to move into these so-called non-tariff barriers, right? Non-tariff barriers, Pulung, you mentioned this in one of my publications, the sanitary and phytosanitary measures. It's sort of a traditional non-tariff barriers. Australia is notorious for this, right? So if you want to import any of the good fruit from Indonesia into Australia, it's almost impossible to do because of these sanitary and phytosanitary measures. Maybe let me just say this. I think sanitary and phytosanitary measures are necessary, but many of them are done because of the farming lobbies in every country, right? The farming lobby wants to protect its own income and its own turf. And that's why we have these sanitary and phytosanitary measures. So we see tariffs, which are easy, non-tariff barriers, and now we see regulatory coherence. Let me sort of bypass the history of the concept. It's not always clear what it means, but the way I understand it is it addresses aligning the procedural requirements for products or services to move from one country to another. And oftentimes these lead to not legal barriers, but what we would call de facto barriers to trade, right? So you have to fill out particular forms, you have to fulfill certain technical requirements, and these then become what I would call third generations barriers to trade, right? So it's not a tariff, it's not a quantitative restriction, it's not an SPS measure, it's much more a procedural requirement that you have to fulfill, right? Tobacco control, animal welfare, energy production are very sort of good examples of this. So Indonesia is not is an example. I'm not going to say whether it's a good or a bad example, right? But if you think about this, Australia basically bans all cigarette sales or advertisement for cigarettes, right? And Indonesia was very much involved in some of these debates because not so much vis-a-vis Australia, but vis-a-vis, for example, the United States, when it came to what was called clove cigarettes. I don't know, Pulung, whether you ever talk about the clove cigarettes case, but this is sort of one of the cases where Indonesia played a major role, right? And so that was simply an SPS measure, right? Or a health measure, rather. And so now we think about sort of completely tobacco control, right? Where everything is banned except sort of sale behind the counter, you can't make advertisement and so forth. So why is regulatory coherence so important? Now, you try to get rid of additional barriers for businesses, that's one. And this is the important bit now. You try to make the regulatory system between two countries the same or coherent with one another. Now, if you have a top-down approach, for example, like the one that I would characterize for China, that's a very different approach to a more business regulatory approach from the bottom up, right? So I'm not saying which one is better. All I'm saying is they're very different systems, right? They work almost in complete contradistinction to one another. And so the idea with regulatory coherence then is more transparent decision-making on the governmental side, right? So that if I want to import something into Indonesia or Pulung wants to import something into Australia, we both know what barriers we may expect. And if, for example, we have regulatory coherence between Indonesia and Australia, Pulung knows what he needs to do to import into Australia, and I know what I need to do in order to import into Indonesia, right? So that's sort of the idea. What are these elements? Oftentimes transparency, right? Just knowing what it is. And we see this before, right? We see some of this before. We see this in the TBT context, in the SPS context. So TBT is technical barriers to trade. SPS is the sanitary and phytosanitary measures, where you had to be able to go to one place, right? Indonesia has one place where I'm supposed to find out where all the what all the rules are surrounding this. Pulung, can you maybe quickly say what this institution is for the students, because I actually don't know what it is. Do you know? Like, there's an information point in Indonesia that I would have to be able to turn to.
Actually, that we also have learned some the material like SPS and PST also, and also the case about the tobacco set. So I think that we can catch up about the material, Professor.
Okay.
Yeah.
So these points of inquiry are really necessary, right? They were seen to be really important. Public consultations, right? That I, as an importer, can somehow have input into what the rules should look like. There's lots of problems with this, but that's not a bad idea, right? So that to make it easier to transport goods from one place to the next, right? That's the underlying idea. Then there's something called regulatory impact analysis. So again, the question is, how much does the regulation that the government puts in impact me as a business? Like, how much more does it cost me? Like, literally, how much more does it cost me? some of these costs are totally necessary, right? Again, I'm trying to think of something that's behind me. There's nothing behind me. But think about the phone again, or the computer in front of you, right? We want these machines to work without becoming electrocuted. That's just a cost. That's regulation. It's totally normal, right? Like, we don't want to get shocked when we plug a device in, right? I remember very distinctly traveling in Germany at the time, even there, or traveling in other places where you plug something in and all of a sudden, like, a water kettle burns down, right? And I'm like, that's not good. That's something didn't work. That's safety we want, right? And the trick about regulatory coherence really is that it involves governments to talk with one another. So it's not like in the past, and that gets me to my next point. It's not like in the past where we had one agreement. We agreed on it and everyone walks away, but rather we now have these institutional arrangements, right? So let me get to that. To these institutional arrangements where governmental, where people from governmental ministries and agencies sit around this table that you see over here, right? And talk with one another, not only at the time when we make the agreement, but consistently down the line for a very long period of time, right? So this then becomes really important, right? And there's a book that was written in 2003, 2004 by Anne-Marie Slaughter on this. A New World Order, I think, was the name of the book. And I disagree with the conclusions that she drew, but the description is completely correct, right? That governments sit down all the time to change some of these rules because they see that things are developing, and that's totally normal. We have new scientific insights. The environment is changing, right? I don't mean the environment itself, but our insights about what the environment needs, right? Higher safety standards, sometimes for good, sometimes for ill. But climate change necessitates that we change the way we do things, right? So the world is evolving around us, and somehow we need to react. If every time something changes, we need to have a big conference, right? That takes 3 years to prepare. That doesn't work any longer. So that's the idea behind that. And so what delegates then do, or what the governments do, is not delegates actually. What the governments do is exchanging information. It's notifying new measures. It's harmonizing efforts, or mutually recognizing the measures that one takes, right? So if I take one measure that is almost exactly the same as the one in Indonesia, we should just recognize them together, right? There should be no separate way that I have to certify that product again in Indonesia and vice versa. And it becomes more important even. It then becomes a tool for policy coordination, right? So we sit around the table and say, this is what we want to do. And now again, we'll get to that in a little bit. Different countries have very different ways in which they think the policy should be carried out. And finally, and we're lawyers, I think we're all, like many students here are law students, obviously, right? It's also about, and I say this against some of our own interests as lawyers, right? It's against, or it's to preempt or to prevent disputes from even occurring, like legal disputes. Like, we're all trained to say, hey, we want this dispute to occur because we get paid for it. But in some sense, it's better to preempt the dispute, right? So the best example I can always come up with has nothing to do with international economic law and everything to do with family law. None of us, right? If you ever find yourself in this unfortunate decision that parents have to divorce, never go to court. It's the worst place to go from my perspective, because once you go to court in a family law matter, it's like this, right? And the worst people off are the children. And so if you can avoid it, come to some kind of agreement beforehand before it goes to court. Same thing here. If you can avoid a trade dispute to become political, right? That's much better. I'm thinking of the national car, Pulung. I think this was another Indonesian case, right? The national car that was targeted in a WTO measure like decades ago now, a couple of decades ago. Or the dispute between Ukraine and Russia, right? A few years ago, prior to the war breaking out, there was a dispute around that. That was very nationalistic and very antagonistic. And if you can try to prevent that by doing these arrangements of regulatory cooperation, in my mind, that's a good thing. Now, like I said, we've seen this in certain areas of the WTO already. We see this in the SPS context, we see it in the TBT, where these meetings in the WTO happen all the time. But these new agreements go further, right? We sometimes see what one calls a horizontal regulatory coherence chapter, right? So there was an agreement that was negotiated but never came to be between the US and the European Union. And then an entire chapter on regulatory coherence, not just sort of bits and pieces everywhere, but an entire chapter saying, this is what we want to do. We want to sit down together and move forward with this. That makes these agreements a living instrument, right? So they don't stand still in time, but they evolve and develop. Again, I'm not saying it's a good thing or a bad thing, but it's a different animal from what we're used to. There's concerns with this, right? So the concern is, for example, that a country like the US or the European Union could basically dictate to a country like Indonesia what to do. Australia may try to do this. In some instances may be successful, but Australia is too small, right? But powerful countries like Japan, like China, like the EU, like the US, will try to dictate this. And oftentimes it's successful, maybe not with Indonesia, because Indonesia is a fairly large player. But if you think about countries that are smaller and less developed, right, they don't have the capacity in the ministries to where they sit around this table, right? The European Union can steamroll some countries that are not as developed. It's just different, right? So that's one issue. So power disparity. China, I think, comes to mind. And China comes to mind vis-a-vis Indonesia and Australia, right? So then there's also a lack of transparency. These meetings don't happen in public. And that may be a good thing sometimes, but there's a lack of transparency. Interested parties cannot intervene. And so here we may talk later on about trade law. And so the parties that can intervene are oftentimes business interests. But if we take trade law seriously, we should also talk about health. We should talk about the environmental concerns that come along with it. And so those groups that may be more on the side of the environment or health concerns may not be able to participate. So that's another thing. And so let me just leave it there. The last two bits are standards and dispute settlement. So standards are actually really important. Pulung, have you ever talked about standards in your classes, or do I start completely fresh?
Actually, that we also talk about the standardization in our country. So
there's nothing new from that I can say. No, I'm just kidding.
This is also about, I mean, like the material is the same because in our curriculum, actually, it's also attached obligatory to understanding about the standardization, including in international trade law and also in international economic as well, Professor. So no need worry. You can proceed.
Then I'll just say what I have to say about standards, right? So we all then know that there's a really important role for standards. Now, and that's good. From my perspective, that's fantastic. So Pulung has told you about my sort of journey to Australia. So I grew up in Germany. I lived in Canada and the US. Canada and the US have the same plugs, right? So I'm just literally talking about the power plugs. It drives me insane, right? So I lived in Germany, different power plug from the US and Canada. Then I lived in Israel, different power plug yet again. Then I lived in the UK, different power plug yet again. And so if you walked around my apartment right now, and I did this today, and I can count 6 different power plugs that I need to sort of figure out what can I do. So at one point I just gave up, and I bought this large package of like 20 adapters. I should not have to buy 20 adapters, right? I don't recall which Pulung, which plug you use in Indonesia, right? Is it the two round ones that plug in, or is it three, or is it two that are sort of look like this? Who knows, right? But if you travel internationally, that's just insane. And that's just that's the most obvious one for me. But there are standards all around you and I, right? The very fact that we can talk on Zoom is based on so many standards, right? The video standard, the audio standard, certain computer standards that can talk with one another. There's a huge area that doesn't sound like it's important, but it's hugely important to make a world run, right? So it's safety standards, right? It's making products to be sold much more easily across from one place to the next. So if you want to, if you're a producer, right, and you have to put in a different production line or you can only produce 1,000 units with one plug, and then you have to produce 1,000 units with a different plug. That's not as easy. It should be simpler, right? On the more complicated side, certain countries have the ability to influence those standards, right? So you may not have heard about this before, but it's a really fascinating sort of area, which is called the Brussels effect, right? Brussels effect basically means that certain countries or certain governing agencies have the ability to dictate what the standard is because the market is just so large, right? So Brussels effect is oftentimes with relation to cosmetics, right, or creams. And the European Union has a relatively strict area or relatively strict regulations with respect to these standards. And so now everyone basically abides by that standard with respect to cosmetics because it's too expensive to have a separate line with lesser standards. So everyone sort of elevates up to that same standard. I would suspect that if you go to most, not all, but most pharmacies in Indonesia, that they would almost only sell products that reach that roughly the same level on safety standards with respect to certain products, right? And so Indonesia did not adopt these standards. They simply were adopted, or they were simply manufactured towards because it's cheaper for producers to do it, right? These standards, as you know, they're not binding as such legally, but they're de facto binding. Because conformity implies compliance, right? So as long as you conform to that standard, that implies compliance. And you see this in Article 3.3, for example, of the SPS agreement, very specifically, and I can talk about this. Now, there's other areas where standards become ever more important. One is environmental and the other one is labor, right? For environmental, the question, for example, that may be relevant in Indonesia is palm oil, right? The use of palm oil and palm oil standards, environmental standards, has riled up Europeans, for example, for a very long time, right? There's a lot of hypocrisy going on, but that's just what it is. And you can also see this with labor standards. Again, an area where I think ASEAN countries are not at the forefront, but if there is an agreement with the European Union, then labor standards will come into play, right? And so if you think about all of that, the technical standards is one thing, but standards become a way to reflect political integration, incorporating values that go beyond merely economic rationales. So one way to think about this is, at the moment, there's a huge debate on which standard to apply with respect to internet regulation, right? China has a standard that is what I would call very much top-down, right? The IPv6 version of internet regulation is much more controlled by a central agency versus the idea of the internet dispersed all over the place without a central controlling function, right? And that is a political decision. If you want to control the internet, then you place the guardian at the top. if you want to believe in freedom to do certain things with the individual users, then you don't do that, right? So that's a standard that sets values, right? So just to show you that, and a German cannot go into a lecture about standards and not cite Mr. Siemens here, right? Mr. Siemens, he who owns the standard owns the market. If you own the standard, you have a very large stake in the market. That's certainly true. Let me come to my last bit of the model, namely binding dispute settlement mechanisms. And here, I don't have a good picture. That's just a boring picture of a dispute settlement room in the WTO, right? There's a variety of forms, varieties of models, and I'll go through this. But basically, one looks really like the courts that you're used to domestically. A judicial model that is with a high degree of independence and permanency of the membership. Then you have these quasi-judicial models that sort of look like dispute settlement, automatic right to go to court, adjudicated by an independent third party, but they're appointed on what's called an ad hoc basis, like the WTO panels, right? And then there's sometimes no dispute mechanism at all. It's all politically sort of negotiated, right? So those are the three models that we see. And if you look at how this works in practice, this is an older chart, but I couldn't find anything more recent. If you look at the year of entry into force at the bottom here, you see that the top line is all of the RTAs in force, so don't worry about that. But what you can see is that the judicial model is the one that is almost never used, right? So countries are very unwilling to give over to independent arbitrators. That should tell you something. Then you have this political dispute settlement mechanism that's in the middle, right around here. And then you have this quasi-judicial model where you do ad hoc, which is here, by far the most prevalent, right? And again, these three things have different applications in the agreements we'll talk about. Why? Because some countries don't want to have or give away the political decision-making process, right? They want no independent judiciary to come in. And so what I'm doing now in the next, I don't know, next 15 minutes or so, I'll walk through all these models in, I think I'm talking for way too long right now, but you stop me, Pulung. I basically look at the degree of integration between low and high, right? And I'm looking at the CPTPP, I'm looking at the RCEP, and I'm looking at the BRI, right? And I can go on and on and on about all of them, right? But, and we can quibble about where to place the dots in this matrix, right? They can be a little bit to the left, a little bit to the right, but the general gist, I think, that I'm trying to show you is the coverage in the CPTPP is really high, right? Huge amounts of areas that are covered. The regulatory coherence is really high. Institutional arrangements, I would sort of put it in the middle. The standards, relatively high again, and dispute settlement, almost judicial. Not quite, but almost judicial, right? And there are a few innovations, for example, and I'll just pick one out of these five here. Wider subject matter means also lots of areas that are subject to dispute settlement. There's a single instance process on an ad hoc basis that's not fully integrated. It's not a judicial model, it's a quasi-judicial model. The enforcement mechanism is supposed to be expeditious, strong, and unbureaucratic. Pulung, if you remember this from like the olden days, right? That's exactly what we talked about when the WTO was created. We wanted it to be quick, we wanted it to be fast and unbureaucratic, right? And so we're trying to reinvent it here again, right? So this idea, but unlike another area that we'll talk about in a second, or another agreement, it's the absence of political organs in this dispute settlement process, right? There is nothing like a council of ministers that has to give an okay. It's just arbitrators that are appointed ad hoc. right? So that's the CPTPP. I'm doing this relatively quickly now because I'm seeing the time is sort of running a little bit. Then there's RCEP. And RCEP looks different. If you just look at where the dots are, right? And this is really all that I want to point your attention to. The dots on the CPTPP are center and to the right. The dots on the RCEP are sort of centered to the left, right? Not nearly as integrated, right? Not nearly as integrated. This is sort of the alternative strategy of Asia towards the CPTPP. My colleague Pasha C at SMU would call it the alternative strategy in Asia. It's sort of an extension of a bilateral web of integrative trade agreements that were already in place between many of the players that you see in the RCEP. I think the economic benefits are relatively limited of RCEP, but the political implications are huge. China, to my mind, is the biggest beneficiary of all of this because China now taps into agreements that it otherwise wasn't going to get, right? And it's gaining market access to a large number of players. It neutralizes some of the disciplines in the CPTPP that it could never, and again, I'm just going to go back up. It could never do this, right? It would never be able to integrate this tightly because some of the CPTPP was deliberately targeted to exclude China, right? So RCEP comes along and China grabs that opportunity from my perspective. It's market access oriented almost entirely. It's really sort of rules of origin based, and I can go into details on rules of origin. But the idea is that the reduction in export costs could be $90 billion annually for the members of RCEP, right? If you look at regulatory coherence, it doesn't appear. Some bits and pieces, but it's really not there. So what you see is ASEAN doesn't seem to be interested in regulatory coherence. It's just because it's market access. It doesn't need it really all that much. Institutionally, incredibly weak. Right, compared to the CPTPP, very, very weak. There is sort of a joint committee. There is potentially something that looks a little bit like a secretariat, but really isn't there. Right, so no power is being given away from the capitals to RCEP itself. Standards, it's a complete rule taker, not a rule maker. And no environmental chapters, no labor chapters. It's economic relations only, right? It's market access, nothing but that. There is a binding dispute settlement mechanism that is sort of quasi-judicial. Lots of chapters, however, excluded, right? So they just they're not subject to dispute settlement. And very much a discretionary enforcement mechanism. It's just not, it's at the hands of political players and not judicial. Now, if you look at the BRI, it doesn't fit on this matrix at all, right? And now you can say, well, it can't because it's a different animal altogether, but it's the project of the century, in the words of Xi Jinping, right? And so it has all sorts of instruments, interstate agreements, soft law instruments, commercial arrangements. It sort of flies in the face of international trade law or investment law. It's everything, right? Subnational entities, states in Australia were able to sign up to it. Universities sign up for it, players sign up for it. It's something different. It's procedurally really hard to grasp, doesn't really fit into the model. Why not? Because I think that China, the government, wanted it to remain incredibly flexible. And if you want flexibility, you can't really go into legal rules, right? So if you want to be flexible, that also means you can play power. And China holds the power in almost every single bilateral relation, right? The only requirement that China puts forth is a mutually acceptable solution through friendly bilateral negotiations, right? You can't access any of the documents. It's sort of a framework that provides maybe market access. It's very vague language, right? Like things like we need unimpeded trade. That's nothing for you and I as lawyers, right? No subject matter is put forth. like trade remedies, like subsidies or other trade remedies like safeguards, subsidies, or dumping. And so those are dealt with in bilateral agreements, but the BRI seems to be taking over, right? Like overtaking those. And so there's no regulatory coherence in the slightest, right? Regulatory coherence, anything like elements are strategically used and not really in the BRI context. Institutional arrangements practically don't exist. There's nothing to deepen them. They're all in the bilateral agreements. But the standard setting, they're there, right? Standards are mentioned quite a bit, but they're Chinese standards. They're not international standards. And again, that may benefit very much the Chinese exporters. They're creating de facto standards. And my understanding, at least, Pulung, correct me if I'm wrong, there's a fair amount of investment in the transport infrastructure in Indonesia coming from China, and basically Chinese trains that are being used, right? Different track widths than anyone else, so no one else can produce for it. I think something similar I read a few years ago about the telecommunications infrastructure. So it's really hard to play that off. So once you set that standard, and once you set the market standard, everyone else is out, right? So Australia, as you may know, has taken a very different role. They've kicked all of Chinese players out of the 5G standard here in Australia, very badly from my perspective. But we have no references to labor and environmental standard. That's not surprising. It's really sort of great amount of flexibility. And it doesn't come with a lot of commitments. It comes with power regulating everything. Right? So dispute settlement, the final bit, it's just not there in the way that we understand it. It's a Chinese court, right? It's literally a Chinese court that takes the law from the Supreme Court of China. It's an international court of sorts, it says, but it's really, you have really just commercial courts in Shenzhen and Xi'an. The Supreme People's Court of China is the lodestar. It's not independent judiciary in the slightest. So if we sum that up, then this is what you get, right? The CPTPP, the RCEP, the BRI, completely different models, as you can see from here, with very different political implications. And let me just maybe end here. I say futures of international economic governance and not one future. I see several futures, right? They're all over the place. And they're exemplified by these three arrangements. To me, the EU and the BRI that we just talked about are complete opposites. One is incredibly integrative. The other one wants to stay away from integration or only on China's terms. Now, the US has been very critical of the Belt and Road Initiative for quite some time. The EU has called China a systemic rival, right? So we see a lot of tensions in these models, between these models. They all have political implications. Don't get me wrong, the EU's model or the US's model has political implications. The US was open about this. At the time, it described the TPP as setting high standard trade rules and providing ambitious liberalization of trade and investment as a counterpoint, that's no longer in the quote, as a counterpoint to China from my perspective. The TTIP that I mentioned before between the US and Europe, also incredibly strategic, wanting to set the standards by the EU and the US. So what we see then is a competition for rulemaking in international economic relations, a competition for standard setting in the 21st century, in today's world more so than in which we're further drifting apart all the time. I think that standard setting becomes really important. And it's really sort of an uncertain and unsettled future over how globalization works in the future. Like I said, we had this kumbaya moment in the 1990s, but now we're replacing these international institutions with this, right? And let me just go up one more. So we're with these different models here, right? And those bring with them very much explicitly and also implicitly, and I think this is important, there's an underlying sort of value battle that's going on that I've tried to at least introduce you to. And with that, all I will say is terima kasih for listening, and I hope this was useful, and please feel free to ask anything and everything you want.
Okay, thank you very much. When you mention about terima kasih, so we must respond with sama-sama. It means like you're most welcome or you're welcome. Okay, I think that thank you very much for such a presentation, Professor Wagner. I think that's very comprehensive because you talked not only in only the detailed point, but also the philosophical also. So that's why that now I think it will give some like the benefit knowledge for our students regarding about the comparison of the PRI, TCPP, and also the RCIP itself or HRCIP. Now we're going to the question and answer, but before I giving the audience, actually that I have a question or maybe several questions that maybe you should respond or we can like discuss in our forum. So actually, Professor, I think I began with basic question actually. Do you think that every country should participate in a free trade agreement or comprehensive partnership agreement, since that they want to make some realization with international governance in economic international law?
So should every country participate in trade agreements? I think every country does. Like, just the reality is they do, right? Why do they do that? Because they think that there's a benefit, right? So it's always about costs and benefits. Some of the costs are relatively straightforward. How much more imports do I get? And how many more exports do I get, right? And so that's a cost-benefit analysis. But I think the question that you're asking is maybe the next step, right? Is this what you've called the philosophical sort of underpinning of all of this? And I do think there's a political, philosophical, economic underpinning to these things. And I try to say that. Should countries do it? I frankly think that every country should decide this on their own, right? For some countries, it'd be really beneficial, I think. I think that so I probably have to explain what I'm saying now. I grew up in Europe, right? And I think that makes a difference. If you think about the European history in the last 1,000 years, I grew up right next to the border to France. The European Union is the only time where we had now 75, almost 80 years of peace in the area that I grew up in the last 1,000 years. And that was because we economically sort of integrated. France, Germany, the Benelux countries, Netherlands, Belgium, Luxembourg, the UK until Brexit, we economically integrated these countries, right? And so I think that's a good thing. I actually think that there is a peace element to integrating economically. The flip side, of course, is that that politicians play off of nationalism, right? I just can't deal with nationalism very much. I'm a child of the European Union in that sense. But should countries do it, it becomes a much more complicated sort of equation beyond the economics, right? Namely, do I want to go into an arrangement with another country? And this is the question I was trying to sort of get to, right? If you go deeply into the BRI, you make a commitment, right? And that commitment comes with costs, right? Because from my perspective, almost no country can compete with China, right? And so I think that's become, and the other thing is that China sets those standards then, right? And so that it becomes impossible to deal with. And so the question then is, do the benefits of having that arrangement with lower costs of import and export and so forth, do those outweigh what I think are high political costs that may come down the line, right? If you again think about internet standards, I don't want to live in a world where someone controls how much I have access to information, right? That's a cost that comes with it. And I think those costs are much harder to quantify. Maybe I'll leave it there.
Okay, I think that's answered the question. I think thank you very much. So now we talk about the one of the material in your presentation. You just like mentioned about the international governance model in the international economic law is one of the elements. It stated that institutional arrangement for regulatory. Simply that in this term that maybe that every country try to be figured out in one vision or harmonize one visions in regarding about to just like systemize about the regulation. But sometimes the problem in here, Professor, we know that the member of the state, if you talk about in the multilateral, for example, like the RCAP, because this is consists of about half developing country and also developed country, and which is that the awareness to be the harmonize. Sometimes it's very contrast with some like the target of this agreement itself. We can say that one of the country try to be dominant, make some like the dominant portion or something like that, or maybe they make some like they have a different mindset or to interpreting regarding about how the content arrangement. So what do you think about this one? Because this has happened in AFTA. Singapore is leading us actually in Australia in AFTA actually that Singapore or a small country, but they have lead us in ASEAN actually. So that is Malaysia as well, and also with Malaysia. But we can compete also to make integrate about the mission with also with our country, the colleagues country, just like maybe Laos and Cambodia. I think that this also have like something not very lucky like as a level like in Singapore as well. So what do you think about that, Professor?
So just tell me the question again in one sort of sentence. Is the question, should we focus on closer integration within Asia or, sorry?
Yes, sometimes they make some like harmonization, like this is one target, but sometimes, the result is this harmonization because sometimes they have a different language actually. So misinterpreting about the standard itself, about the policy itself. So what do you think?
So I think, again, maybe I'm just biased, right? The European Union is overcoming 27 countries with almost as many languages, right? So I don't think the language should be, to me, isn't the problem. I think that requires putting some resources into a translation service, essentially, right? But I think the benefits of more closely integrating outweigh sort of the costs, right? And the problem, of course, is how much nationalism do you want, and are you willing to sort of step back, right? Again, I'll come back to the national car in Indonesia. I think the national car in Indonesia was probably a necessary thing, right, in order to bolster the ability to manufacture. It was just badly implemented because it was so nationalistic, if you will, right? And probably a bit of corruption thrown into it as well at the time. But if there is integration, it requires other things, which is why I say the European Union is a bad example sometimes. Because the European Union is able to sort of, like, there's funds, there's huge amounts of money that go from one country to the other, right? And I can't see Indonesian taxpayers wanting to fund projects in Laos, right? And so that's a really hard sell. And I think that came very much over time. That took decades to really do. But I think the dividend, if you will, the benefits just were outweighing the risks, right? That's, I think, the tricky bit. Now, I would always start off relatively small and see whether one can build some kind of consensus, right? And then build slowly on top of one another. And maybe there's different integration speeds that countries take, right? Say, I don't know, Indonesia and Malaysia, to my mind, are, and I'm not going to go into the history, right? That's complicated and everything. But to my mind, the ability of certain Southeast Asian countries, for example, to integrate should be relatively high, right? So at least with Indonesia, you shouldn't have much, between Indonesia and Malaysia, you shouldn't have that many problems with the language, right? It's slightly different, but it's not really different. So you can talk across borders. But I think the politics are really coming in the way, right? And then, of course, Laos and Cambodia are not exactly democracies. or anything resembling democracies, right? And so then you talk about a completely different ballgame. So I think for the time being, we're largely looking at sort of the ASEAN model that I outlined in the RCEP, unfortunately.
Okay.
Yeah.
Thank you for this question. I think that it's like enlightening. I think that is also my point actually. So before, is there any question from the audience, please? Because actually that the audience who joined today is not only from our university, but also from the another university like University of Indonesia and also Gajah Mada University as well. So actually that I just like maybe proceed from the audience that want to address question from Prof. Wagner. Please just like use about the feature raise your hand, and maybe you can also state your question directly to the Prof. Wagner. Is there any? Okay, maybe they're still thinking, Prof. So actually I will asking question again regarding about the standard. So actually that when we make some about the agreement, or I mean like international trade agreement with some like the country, for example, like we make also the standard. Sometimes the standard takes a long time, the negotiation between the two country or multilateral country. After that, maybe they enacted in one regulation. I mean, like in one legal instrument. Sometimes they also have a conflict too in the future. For example, like, you know, one of the country, it can be, don't have any capacity or maybe cannot fulfill about the standardization when they make some like the export or import regarding about the process based on under article. But one of the pleading of this, like the country who already accuse it because this not fulfill standard, they always mention this is discriminate us because actually you're always using about this the clause and also the statement under the article. Actually, that the article itself is just like approve your political interest or your interest is out in this case actually. So sometimes that, you know, discrimination is always happen after the feature of the post organization is enacted. So what do you think about that, Professor? Because it's not only developing countries, sometimes developed country as well is also have, you know, exporting childish.
Oh no, look, developed countries are exporting standards all the time.
Yeah.
They do, right? So if you look, again, I come back to the SPS, right? The sanitary and phytosanitary measures. The drivers and that's all outsourced, as you know, right? It's not in the WTO. It takes place in the FAO, the Food and Agricultural Organization, right? The Codex Alimentarius Commission. No one's ever heard of the Codex Alimentarius Commission, but it sets huge amount of standards. When we get up in the morning, the toothpaste that we use, the creams we put on, oftentimes are done by the Codex Commission, right? No one's heard of it. And they're not binding standards, but by way of the SPS agreement, they become binding standards, right? So, and recognize that that happens. The Codex Alimentarius Commission is basically, to my mind, it's an important institution, but it's very much driven by private interests. Because if you look at the standard setting models in different parts of the world, the European Union, I would say, sort of a mixed model between government and the private sector. In the US, the standard setting is much more private sector driven, right? And so large private sector institutions will basically come in and then say to the US government, this is the standard we think we should set. And then we're trying to use that standard everywhere in the world because it makes it easier for us to then export to other parts, right? My own take is that it doesn't really, I don't think that developing countries oftentimes, and I'm not saying that's a good thing, quite to the contrary, I think it's a bad thing. But I think it's a really hard battle for developing countries, even countries like Indonesia, to try to set standards, right? So the influence that countries like Indonesia have probably isn't large enough for the standard setting. So to my mind, a country like Indonesia would almost be better off to have a long-term project to try to get into the standard setting business. The funny thing is, China is doing this, right? So if you look at out of the three most important standard setting organizations with respect to IP, two of them are Chinese, headed by Chinese nationals, right? And that's a deliberate strategy by China. So the question then is, do those international standards disadvantage developing countries? And sometimes they do. So that's where I would work on, right? And saying sort of putting the spotlight on how the standard setting disadvantages farmers from Indonesia or from places like Kazakhstan and Kyrgyzstan, because there's not a cooling chain that goes all the way from production to, right? So I always bring this up, this example, and some of you may now think that I'm slightly crazy. But in a former life, before I became an academic, I bicycled from Germany to China. For 10 months, I was on my bicycle and cycled from Germany to China.
Wow, it's good.
And in that process, I came through Tajikistan, right? Tajikistan, small country, most people haven't heard of ever. Somewhere in Central Asia, bordering Afghanistan and China. Fantastic tomatoes and cucumbers that you can never buy in Europe, because the standard is cooling chain from production all the way through. And that is simply not possible in a country where you have rolling blackouts, right? So it's just like you can't export, right? That's the standard setting right there. That's the power of standards. So I don't know that, unless it's a long-term project, I don't think it makes sense to try to engage in standards. And most countries don't have the capacity. So I've trained people in ministries. As soon as you train people in ministries, the private sector snaps them up. They're gone, right? Just the very fact that you trained them means the private sector thinks, oh, they're good, let's take them, right? And even if it's in an unrelated area. And so I think it's really hard. There's a structural disadvantage here.
Yeah, the fact it's like some of them is like disadvantage us in developing country. We can learn also from the China. I mean, like from the considerably that the country like Laos and also now.
Can I? We have someone who raised their hand.
Oh, finally, yeah, finally. Okay, now that Mika is also international student in our university, Prof. Actually, that he's from Madagascar. So, Mika, you can address the question, please.
I'm audible.
Yes, of course, you're audible.
Okay. So good afternoon, everyone. My name is Miki. I come from Madagascar, and I'm actually a student at the Faculty of Law of UNDIP. So first of all, thank you very much for our speaker today to share a very interesting topic. I will refer my question to the, how to say that, the free trade agreement, which according to some researchers, so as you know, that any agreement will create advantages but also disadvantages, and especially for developing countries, it creates disadvantages for the local companies or the local industries, especially regarding the how to say that, the free taxation for the foreign companies on their products. I will take an example for my country. Let's just take an example. We have industry producing oil in Madagascar, and this is a local industry in my country. But as Madagascar is integrated into a free trade agreement, there are foreign companies that are produced also. The competition in the price, and the local industry in Madagascar is actually in decay because they can't compete with the price of those foreign companies, which due to this free taxation, they can lower their price, and of course, the price of the local company is quite higher, but the people will more like prefer to buy the foreign product rather than the local product. So what is your opinion of, because it creates disadvantage for the local companies, especially for developing countries? And also a second question. It also refers to the developing countries. It creates disadvantages also for the developing countries government, because sometimes the government can't compensate the reduced tax revenue. So like the tax that should how to say that, like enter into the government finance, they can't compensate it sometimes. So it creates a disadvantage for the government's revenue. So what is your opinion? Thank you very much.
Mika, if I can ask you, can you repeat that second question again? Because I don't think I quite caught it. Sorry.
Okay, so to make it simple, the reduced tax revenue, it creates disadvantage for the government finance, because sometimes the government, especially in developing countries, can't compensate those revenue. Yeah.
Okay. So I think I understood the concern. I think it's a concern that's raised quite a bit, right? Don't get me wrong. It's a perennial question in international trade law. It's a perennial question in international investment law. I'm afraid I probably don't have the answer, but if I could wave a magic wand, I would, because I strongly believe in non-discrimination, right? That's my starting point. And so, but I don't know that what you're pointing to is necessarily the fault of international trade agreements, right? So the first thing I will say is I don't call it free trade agreements. There's a reason for it, because I don't think that regulation is ever free, right? There's nothing like free trade. There's a trade agreement, but it's not a free trade agreement, right? That's number one. Because free trade agreement implies there's no rules. There's always rules. There's always rules, right? Now, the tax advantages is something where most often they're done in order to incentivize investment in the country, right? To my mind, that's less trade law, that's more investment law. And those investment law rules are highly problematic, right? Because, as you say, they advantage the foreign company potentially for some time, oftentimes, against the local industries. And you see this, for example, in areas such as at the time, the North American Free Trade Agreement, right? There was a large amount of corn that was, for example, produced, and a huge variety of corn that was produced in Mexico. And that completely gets sidelined. Huge varieties, we're actually much better tasting and everything, get sidelined by the imports from the US to Mexico, right? US farming gets huge amount of subsidies. And I think all of that comes together, Mikhail, right? I think that's the concern that I think you raised. Whereas, did I hear this right? You're from Madagascar? Okay.
Yes, Professor.
I found that surprising, but fine. I didn't expect that, but Madagascar just can't cope with that. By the way, Madagascar is on the very top of the list I ever want to visit. Like, I've told my partner, it's good. I don't care if I have to rough it. I am totally willing to go anytime and be photographer and do anything else. I want to go to Madagascar really badly. But Madagascar just isn't in a position to provide any counter towards the subsidies that are being given in, say, the agriculture space, right? And I think that's probably what you're driving at. Tell me that I'm wrong, right? So to my mind, we need to continue, like, developed countries need to continuously reduce subsidies being given to farming interests. Now, try to tell this to people here in Australia, right? You always claim there's very little subsidies, right? And on the face of it, that may be true, but there's huge amounts of grants being given. But the European Union is giving subsidies to farmers. And I think, unfortunately, this will not end. And I'll tell you why. The war between Russia and Ukraine, I think, has given us an idea of what may happen if you're not self-sufficient, right? And self-sufficiency then implies that you do certain things in order to prop up certain interests. So if you think about potash, fertilizers, wheat, and so forth, all these products are going to increase in price because of the war between Ukraine and Russia. Same thing with construction materials and wood and so forth, right? Do I think that we should reduce them? Yes. Do I think that foreign aid should be structured completely differently for self-sufficiency rather than for German companies getting subsidies for exporting their goods into places like Madagascar or Indonesia? Or again, bike trip from Germany to China. Markus bicycles through the Punj River Valley between Afghanistan on the one side and Tajikistan on the other, what do I see? German-built German-built diggers that were stranded at the side of the road. I can almost guarantee you that some of them were bought with German taxpayer money. That's a subsidy, right? So the only way that I think that can work is to reduce the subsidies being given for exports, such as this, to tackle development aid, and to much more strongly provide infant industry protection for developing countries. The problem with all of that is that that requires non-corrupt, transparent policies in the target countries. I'm sorry to sort of like, I don't have the answer, right? It's like a package of things that have to come together. And frankly, I think that developed countries need to stand up to their own constituencies, and they don't, because elections don't work locally or domestically. They don't work internationally. I would probably call myself, I do call myself a post-nationalist, right? I strongly believe in sort of having a larger view, but I am definitely in the minority. I think for a brief moment after 1995, there was this idea of the international moment where you could hold hands together and say, we're going to do this together now. I think that moment, unfortunately, has passed. And if anything, the war between Ukraine and Russia and lots of other wars, like in Tigray, they show us that we're going backwards, right? Reduce tax revenue for developing countries. I think that sort of follows up on what I said. I don't know, Mikhail, whether you want me to say more about this, but the whole point is, from my perspective, to strengthen certain industries that developing countries have already, right? And then build forward to the next. That's, I think, the trick, and we haven't mastered that trick. We're terrible at it, as a matter of fact. I'm sorry to be sort of a downer. I'm German. I'm very direct. And if I were to speak, if I say something positive, I mean it. And if I don't see it positive, I'm like, I don't know what we can do, right? Short of convincing domestic constituencies that they will get less. And that's a really hard sell politically. Even, I would say, in Madagascar, that's a hard sell politically, right?
Okay, Mikhail, you want to have follow-up or not? Or I think that this is enough to answer your question.
Oh no, Mikhail, look, Mikhail, if you want to come back, no one else is raising their hands, right? So Mikhail should speak.
Yeah, maybe just a last question. A minute. You still can see my face, right?
Yes, of course.
Not anymore.
Yeah, actually, I have a last question regarding the theft of intellectual property. You may correct me if I'm wrong, but based on my research, like many developing countries don't have laws, like strict laws to protect patents, inventions, and the new processes. The law they don't have aren't always strictly enforced. As a result, corporations often have their IDs stolen, and they must then compete with the lower price domestic knockoffs. So what is your opinion regarding to that, sir?
Look, when I was a student and for some reason I ended up doing projects in Uzbekistan, right? I bought low-cost Microsoft Office packages on the streets of Uzbekistan, right? It cost me, I think, $5 US at the time, right? I think that's something that lots of companies are building into their price model, right? Now, IP is a really wide field, right? And I think IP, so I don't want to open that whole barrel, right? It's just too large a field. But I think intellectual property protections have gone way overboard, number one, right? So we know, if you look at the history of IP protections in international trade law, even the very name TRIPS, trade-related aspects of intellectual property rights, that's a terrible name. It's not goods, it's not services, it's something else, right? But it's one of the three main pillars of international trade law, right? So look, the IP industry in the US was the driver to include it in the WTO, right? I think IP protections have gone way too far, right? If you look at patents, if you look at copyright, the protections that are given for certain products in a widely understood, not in a technical sense, they go way too far, right? Lifetime of the author plus 70 years or something like that. That's just crazy, right? So that's number one. Number two, I'm a big believer that you need to provide incentives in order for IPs to actually work properly. I get that, but I think we've taken that just way too far, right? If you just look at things, I want the Pfizer's, well, let me not say Pfizer, but I want the BioNTech, right? So let me pull my Germanness out, right? BioNTech was the company that created the Pfizer-BioNTech vaccine. I want them to be able to make money. I think that's apparently that's the only incentive we have for people to invent. But the question is how much, right? And what is obscene sometimes is the sheer amount of money that some people are able to make. I've always said that people like Bill Gates or others, they were great at what they're doing, but they're not that great to make 50 billion or 60 or 70 billion dollars, right? As their own property. That's just, to me, way too high. So I think it's a process of recalibration much more than anything else.
Thank you very much.
Okay.
I'll answer my question. Dankeschön.
Well, okay, thank you very much for Mikia. Professor, no, you can pay attention on the chat box. There's a question on the chat box from the Karenina. Yes. From Karenina, you want to asking directly, or maybe I will read for you, Karenina. If you want to ask directly, please go on. Hello, Karenina.
Let me just read it really quick.
Okay. There's a question, Prof, regarding about your statement. I think that she heard you that you mentioned about the example, the country like China is always has the upper hand on many bilateral agreement. At some point, China's standard may not always be beneficial for other country involved. My question is, what do you think is that the best thing to do, the best action to take a small country to get best benefit out of all bilateral agreement despite the standard as the other country, which hold more superpower? Yep. So back to you.
Oh God. So I think there's 2 or 3 prongs to that answer. Number one, it has to be a long-term strategy to be engaged in the standard setting that exists on the international level, right? That's one. Number 2, multilateralization. That follows from that, right? Namely that do what the most one can do in order to rely on the multilateral standard, right? Because I do think that those are more beneficial in the long run than standards set by one country only. And number 3 is agreements like RCEP. Let me just explain why I say agreements like RCEP. Agreements like RCEP or CPTPP or others allow for better arbitraging in negotiations. What does that mean, right? If you can negotiate through a triangle, or if you can negotiate as many against a powerful actor, you're better off, right? So Indonesia vis-a-vis China doesn't stand much of a chance, frankly, right? But if you go back to RCEP, for example, if all ASEAN countries could agree on some kind of standard that they all want to have, China may actually start to listen, right? So I think Pulung, you asked me before about integration, right?
Yes.
That's the benefit of integration, that you can then provide sort of this common front against
consensus, like my consensus.
Well, the thing is, you have to first have the consensus internally, between them, which then allows you to project power outwardly, right? So I think, and that then comes with all these these trade-offs that you have to be willing to make, right? That you can't sit there and say, this is how we do it on my own, but rather we've built this consensus over the long run, right? But that is beyond, and now we can hopefully see, this is actually a really good question, right? Because it says, it allows me to point this out again. It goes beyond market access. A market access agreement does not allow you to do this, right? There you basically have no lever to pull, especially if it's like China, which is a powerful exporter, right? But if there is more than market access, and ASEAN doesn't want to do this, right? And I can understand why, which is why I think the CPTPP may almost be like a better place for some countries to join, right? Because that actually provides a bit of a better cover. Yeah, let me maybe leave it there. But Karenina, if I haven't answered your question, please come back either through chat or by showing your face and asking.
Karenina, okay. I
Uh,
think that's the response.
yes. Oh, right. Look, we've all been there. Trust me, including in Australia, we've been there.
Yeah.
So many times, right? Where very quickly my internet connection drops. I'm teaching. I'm taking my phone, and I'm like, let me hotspot really fast right now. Something happens.
This is like the barrier, like in international trade law, yeah. It's also a barrier from the online learning, in like just in using Zoom. Okay,
Indeed. I think, and it happens everywhere.
Yeah, I'm so sorry for that, Professor. So
No.
that we waiting another question. Is there any question or not? Because we still have maybe 10 minutes left. Okay. Maybe I will nominate the name, because actually that he already sent the message direct to me, or direct message. So maybe I will call the name. Achal, you want to ask him the question or not? Hello, Christina Nicolen.
Yeah, I'm pausing for a moment. Okay, I think for me it's a little bit related to Karenina's question. Earlier in your presentation, you mentioned that in the international or in the future that there will be some fragmentation with regards to the international agreements on economy. Do you think that it will somehow be an obstacle for the system in WTO? Because in the WTO and the GATT, it definitely makes a standard for international agreements, specifically in economy and trade. And if we use, or if in the future there will be a fragmentation on the state who is more, or let's say who have more power, or who has more uniformity in the terms of the model agreement, do you think that it will disrupt the system that has already been made through the WTO and the GATT? Thank you.
Okay, back to you, Professor, to respond to the question.
And thanks, Christina. I do think we will see a fragmentation and siloing, right? And that has a lot of effects. I think that the multilateral institutions are weakened by that. And I think that developing countries, and I've said something very controversial at one point in a class that I was teaching in Africa for mostly government officials, right? It's nothing to do with trade. But I said at one point that I think some governments would wish for the World Bank to come back, right, as a lender. You may not like the rules that the World Bank sets, but you know that the rule of law sort of gets followed through. You know what the rules are, right? The question is, when you go away from multilateralism, coming back to your question, Christina, when you go away from multilateralism, you may still know what the rules are, but you can't influence them at all, right? So I know I may sound a little bit more critical of China than some people may like, but I am quite critical of the way that China is conducting its business, right? Because it is very much a power play that's being done, right? And China is within its right to try to do that, but I don't think that developing countries are necessarily benefiting from it, right? China's ambitions are many, but one of them is also to mollify its own domestic constituencies, right? And otherwise, you don't remain in power if you are the Chinese Communist Party. It's fairly simple, right? I mean, the Chinese history is full of uprisings and revolts throughout history, right? And the way to do it very successfully, the Chinese Communist Party has elevated millions and hundreds of millions of people into places where they are economically fairly happy, right? That's to their credit, I must say. That said, that has come at a huge cost, right? And now one of the costs is outward projection of power and a fair amount of nationalism. And I just, as a German post-World War II, I just hate nationalism. I just think it's one of the worst things we've ever invented, is to be nationalistic. We're seeing that now. What does that leave us with? I do think that strengthening multilateral institutions is probably the way to go, even though you may not like everything that those multilateral institutions do. One of the things that I think we're seeing a little bit in the last 5 years is a movement in these multilateral institutions to become a little bit more cognizant of the things that 10 years ago they wouldn't have said, right? Redistribution. There was a report that came out roughly 5 years ago from the WTO, the World Bank, and the IMF that mentions the word redistribution several times, right? In order to have a more level playing field between different players in each country, right? So that social programs, and that was something that the Washington Consensus would have obliterated, right? Like 20 years ago. So I do think we're seeing movement overall, right? It's always pendulum swings in history. It always goes back and forth. We go towards a more neoliberal, and then we go away from it, and then Thomas Piketty comes in, and other people who write books that seem to be influential. But it's always like that, right? It goes back and forth. Christina, does that answer your question at all? And you can say,
yeah,
and you can say no, Christina. That's totally fine.
I think it answers it a little bit, but what I want to ask a little more is that how will strengthening the multilateralism organization will help the developing state? I mean, as you said that we may not like it, so do you have I want to know your thoughts on what should the developing states do in the position where even joining the multilateral organization is not really beneficial for them, or should they just be participating and change it from the inside, or should we really just depend on the power state who actually have control or more power in that terms or in that factor?
Look, on that front, I think I'm relatively set. I think in working within the institutions rather than against, right? Because the one thing that strikes me as pretty obvious, so this was in the context of Brexit, right? It's a completely different place. But the UK wanted to really go into Africa and find these old relationships and rekindle them, right? And my point to these officials was, you will all be approached individually. The best thing to do is to talk with one another and be open with what you're being offered. And then collectively go towards London and say, this is what we want as a collective. And the problem is that they were all, that the Brits knew that they could buy them off. If you pick one individually, you can buy them off and then everyone else folds, right? So I think the problem is, and I don't know that I have a good answer for you. We would have to, and I understand that countries may not be able to hold off, right? To do that. So the question is, do developing countries have the will, the ability, not the will, it's more like the ability, right, to not be bought off? And politicians have the capacity to say no to something that sounds really good in the short run, right? So we're running into another problem, which I will only just flag. If it is a democracy, our 4-year cycles are too short. Election cycles are oftentimes too short to actually accommodate those types of changes. I hope that answers it better, Christina. I do think that multilateral institutions are the way forward. I do see one question, Pulung, from
Angel. Yes.
What if the we made?
Actually, it's reading about how quite the case study. Yeah, actually, that asking about your opinion about what if an item has been made major import and purchased by many people and turned on unexpectedly the standard ingredients, for example, don't match with the standard. I mean, they asking about as this case that now counteract regarding salmonella bacteria. Does the agreement provide a sanction, or how to solve the problem? Do the recall it takes a long time, and does it affect the country for the distributor? It's regarding about the case, Professor.
Yeah, so look, the Kinder egg is something I grew up with as a German, right? Because I think it was originally, it came from Italy and then very popular in Germany. I don't know anything about this particular case, but to me that strikes me as a commercial question, right? First and foremost, the manufacturer will have an interest in taking it off the market as quickly as possible. Because you don't want to be seen as a brand that makes people sick. Pretty plain and simple. That said, something clearly went wrong, right, in the oversight mechanism. And that comes back to questions of governance. Namely, my first inkling is what went wrong in the oversight. So either the manufacturer did something wrong, most likely, but also was there any means to prevent this by having oversight mechanisms? And maybe there weren't, right? Look, we can't hedge against all risks. It's just impossible, right? The question is, what do we do about it? Investigation is my first sort of thought, right? Investigating, was there some corruption potentially going on in letting this go through, and with knowledge, if there was, then fine the officials that were at fault. If there wasn't, to some extent, there is a risk in everyday life that some products are just not that. Now, should the manufacturer carry the burden for things that have gone wrong? From my perspective, yes. But I don't. Is this an Indonesian case, Pulung?
No, actually, that's not case. Yeah, the
No, it's not a case, but it's a situation, right? I'm trying to think. Salmonella and Kinder eggs don't strike me as things that actually work together very well, because everything in the Kinder egg is dead. And salmonella would have to be a sort of some kind of live product normally. But I could be.
Yeah, in Indonesia it's still happening now, because actually that it's assumed that actually the ingredient is content about the bacteria. So now that all the supermarket is just like withdraw all have the things, because actually that is accusation, Professor.
Yeah, but that to me then is a liability question for the manufacturer, right? Yes. And as long as, I don't think international trade law has much to say about this. It's a liability issue for the manufacturer. As long as the officials, like official agencies, they know of the problem, they then sound the warning bell. That's really all you can do. It's not a trade law issue, because the standards have presumably been kept, at least somehow, but something has happened in the chain, right? That's probably where it is.
Okay, I think that's just, they just like wrong about this direct question. I think it's okay.
No,
we can discuss as well.
It's complicated, but I don't know that's a trade law issue. I think it's sort of a sanitary issue within the country.
Okay, so I think that we were going to the end of the section, Professor. So before that, I close about the section of question answer. Actually, that maybe I will give you the 5 minutes, or maybe 3 minutes or 5 minutes to deliver about your closing statements regarding about the material, or maybe about our wishings collaboration.
I had no idea I needed to do a 5-minute speech at the end of it. No, that's okay. Look, I'm hoping, right? So number one, thank you for being here, and 150 participants. It's an honor that you're all here. I hope this was useful, right? In the sense of trying to get a sense of what I think is a more intricate and more political sort of issue, rather than the hardcore legal sort of question. But I think law has something to say here, because you can look at the legal questions and then draw some conclusions from this, right? And the one sort of element that I always find sort of useful when I give this or when I think about this topic, right, is let me just sort of pull this up again, and let me just try to find this really quickly. Is this slide, right? So I know that oftentimes you don't end with slides, and I don't want to have a lot of slides. I'll show this very quickly only. Is this, right? Hang on, I hope you can see this. Is the difference between these different models, right, is huge. And I think knowing this is actually helpful in trying to figure out what kind of model an agreement fits into, right? And whether one would want that or not, right? my own take is that the BRI is attractive in some ways, but only at first glance. It comes with too many costs involved, right? So that's sort of where I would leave it, and that was the goal of the presentation, and I hope that's what came across. I, for one, am really interested in what goes on in Indonesia. I'm trying to follow it as much as I can, because I do think that countries like Indonesia are the building blocks of the future of the Indo-Pacific, right? And I think, again, you probably have seen this now, is I think of trade agreements as strategic sort of objects almost, right? So that there is I do think that there is a contest of ideas and a contest of systems, and they're playing out here. They're really playing out here. So that's sort of, I don't know, maybe trade law 2.0 or 3.0, right? Or 4.0, who knows? Yeah, so that's sort of the world that I travel in. If anyone is interested in this, please get in touch. If you think that you want to do a PhD in the future, please be in touch, right? This is the kind of work we do. We just started another project that sort of fits with that, is weaponized trade, right? To use trade as a weapon in the absence of military, right? To use trade as a weapon to get countries to change their behavior. That's the kind of sort of thinking that we're doing at the moment. And again, thanks for having me. I hope this was useful, and I look forward to actually meeting everyone in person.
Okay, I think this is obviously useful and gives some like beneficial for our student professor. Actually, I think once again that this is an honor also that you accept our invitation. So you promise us, right? You will come back in the next year regarding about the webinar. And also, I think that I will also proactively to following up regarding about have the collaboration between our institution about the Faculty of Law Universitas Diponegoro and Wollongong. Since that, you know, we have already 3 PhD from Wollongong University, especially in 2 of them is from the law of the sea. It is a concern, and one of them she's concentrate in food and security. Actually, because that's
well,
that,
then we need to have some more trade law people then.
Of course. So we try to have nominate. So that's why I address. Okay, you going to Prof. Wagner because that's very expertise about that. Okay, I think thank you. Yeah, I think that's all. Thank you, Professor. So I do apologize for maybe if I have mistake or error to leading I think that this agenda or this webinar. So now I giving back the floor to Christina. Time is yours. You might take the floor, Christina.
Thank you so much for Professor Wagner and Mr. Pulung for the presentation and discussion. Right now, as we already finished the discussion session and the lecture session, I would like to welcome all the participants to turn on their camera and take position for the photo session. And while we wait for the participants to turn on their camera, I would like to remind the participants to also fill the absence link in the chat box.
Okay. Turn on the camera, please. Okay, so.
All right, the participants, could you please turn on the camera, and I would like to remind one more time to fill the absence link in the chat box. Okay, I think there is no other person who's going to turn on their camera, so the photo will be taken on my sign. Okay. Okay. 1, 2, 3. Okay. One more time. 1, 2, 3. All right. Thank you so much for the photo session and turning on your camera. Now, right now, I would like to thank you all of the participants, the lecturers, and also the lecturer itself, the Professor Markus Wagner, and the moderator, Mr. Pulung Hananto. We have come to end of the session, and it has been a great time and wonderful afternoon. That will be the end of the session. Thank you very much for your attention and participation. Have a nice day.
Thank you, Professor.